Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here today for oral argument in our case number IC18-0052 Mo versus Baza. Counsel, each side has 20 minutes for your argument. The appellant may reserve a portion of that time for rebuttal. If you decide to do so, we would ask that you keep track of time yourself. You have a clock on the podium. These proceedings are being audio and video recorded, so we would be grateful if you would identify yourself and your client when you begin your argument. We have read the briefs, discussed the case at conference, and are familiar with the arguments raised. Please keep that in mind in making your arguments, and with that, you may proceed.
Good morning, Your Honors. My name is Dennis Kurth, and I am with the law firm of Snow, Carpio, and Wheatley, and I represent the petitioner, Jim Mo. It's particularly nice to see Judge Catani this morning. Judge, I know you've been to our workers' compensation annual seminars before, and as a practitioner and a member of the workers' comp section of the bar, I want you to know that we've always appreciated your appearances and your input, as it's extremely important for us to know what the Court of Appeals is thinking and how they're handling workers' compensation cases. Now, as I prepare for this most anxiety-provoking moment of legal experience, I try to anticipate what kind of questions you might ask me. I review the cases again. And one thing I wanted to start out with this morning was, first of all, the issue of whether this injury was slight or trivial, because as we know, the law with the statute of limitations, the statute and the case law, is if the original injury is slight and trivial, then there may not be a reason for filing a claim. That if a injury becomes manifest later, the statute of limitations should begin to run from the time that that injury becomes manifest. Now, the administrative law judge in this case, with all due respect to her, said that this injury that the applicant had, the petitioner, was more than slight or trivial because of the, quote, extensive imaging that he had. Now, the extensive imaging, of course, is basically all he had after this truck accident. There was a traumatic truck accident, well-documented DPS accident report that occurred. The Mr. Mo did go to a doctor the next day because he had a regularly scheduled diabetic appointment. But if you look at the records, you'll see that practically all of the medical attention he received was to get diagnostics, simply x-rays of his right side, his knee, his wrist, his hip. So, and the reason I bring that up now is because I was looking at the Pacific Fruit Express case again last night, and I see that the employer in that case actually raised the question of whether there was enough there for the claimant to have filed a workers' comp claim, because most of the initial medical treatment was simply diagnostics and not actually treatment at all. The court said for an injury to be serious and not slight or trivial, the symptoms must be of, quote, sufficient magnitude. Then they go on to say that in addition to symptoms of sufficient magnitude, the, quote, awareness of the permanence of a condition is a factor when determining the magnitude of the injury. Then they conclude in the next, now a couple pages later, they say that they're not going to decide, in this case, the question of whether an injury that results in mostly medical expenses for diagnostic workup is actually medical treatment. So Counsel,
let me ask you a question. There's a case, Sherman versus Industrial Commission, 158 Ares 177. Neither you or your colleague cited it in your briefs. Are you familiar with that case?
No, I'm not, Your Honor. I'm very sorry to say that. But and the reason is I thought the case law that we have is a perfect fit anyway for the facts.
Okay, go ahead.
So it's still the position of the petitioner here that this injury was slight or trivial. Most all of the medical attention he received, which was basically accidental to begin with because he went to his regularly scheduled medical appointment and didn't even bother to ask for medical care when he went to Concentra the night before. Pretty much all of this attention from the doctor was diagnostic. X-rays of his hip, knee, wrist, and then he has to come.
What about this argument that your colleague is making that your client knew certainly that there were several injuries, including a flesh wound, and that he needed to file something at that point. That's when the limitations clock began, and that subsequent injuries that might develop, might become serious enough, are to be reopened rather than filed in the first instance, and so there's no limitations problem.
And that, Your Honor, I think was the key to the ALJ going off the track on the real analysis. The judge even used the term compensable consequences, I think in paragraph 12 of her initial decision. She said the original truck accident triggered compensable consequences. And I know the respondents have raised that in their brief too, but compensable consequences is a nice doctrine to apply in a case where somebody has filed an original claim and then later develops something unforeseen in the future that you can argue is a compensable consequence of the original injury. But it's compensable consequences is not, in my opinion, a doctrine to apply to prevent a claimant from having a compensable or timely filed claim in a situation like this. Judge, you said there were injuries. Basically, all the doctor diagnosed was pain. That's it. Hip pain, wrist pain. No injuries were diagnosed. No sprain, no broken bones. The X-rays.
But you concede, though, that the limitations period started on that day for those, whatever you call them, pain injuries, right?
I would agree with that, absolutely. And that's why in our brief and two briefs, we've always said he could have filed a claim. I mean, if he had come to me right after that, I would say, yes, you could have filed a claim for that because you had some X-rays done. But the fact that he didn't, because it wasn't scheduled as a medical appointment for whatever happened to him, he just offhand told the doctor, hey, I was in a truck accident the other night, and the doctor said, okay, well, we'll X-ray your soreness. But there's no indication that he would have gone to any doctor on his own just for those injuries. Yes, I would agree. He could have actually filed a workers' comp claim to get those bills and X-rays paid for.
And what's
Sorry, can I ask a follow-up question? Assume he had some broken bones with the first, went immediately afterwards and actually filed a claim. What type of limitations would there be? And I'm just asking, I just thought of it this morning on the way down, but what kind of limitations would there have been on reopening the claim? If he had filed an initial claim, several broken bones, and then an infection develops a year later, is there a limitation on when the claim can be reopened, or?
No, there's not. The claim can be reopened anytime during the rest of the person's life as long as they can prove the existence of new or additional or previously undiscovered disability. So that's why I'm saying anything that would have happened, like if he had actually filed this claim based on the first visit to the doctor, then yes, the finger problem could have been treated as a compensable consequence of that injury. There is no time limit on reopening. But what I'm saying...
So I assume there is a time limit just based on... What in your view when did the statute of limitations commence on the finger injury?
In my view, as I said in the briefs, on the April 10th, 2017 note of the doctor, that was the first time he recorded a history of a laceration in the finger that didn't heal, and the first time that medical treatment was given, and that was simply the prescription.
Does it have to be a diagnosis or a visit to the doctor, or could it be when a reasonable person would know that they had a compensable injury?
Yes, under the case law, Pacific Fruit Express, Henry, that time should begin to run when a certain diagnosis had been made. In this case, I could have argued that didn't occur until the MRI was done on August 10th of 2017 that showed
That's the osteomyelitis.
The osteomyelitis. But
you're acknowledging that if he had reason to believe that he had a relatively serious condition, even before he went to the doctor, at least at that point, in your view, whatever that point is, was within the statute of limitations, but not necessarily on the date that he went to a doctor.
Correct. So what I said was that on April 10, 2017, Dr. Makija first notes this laceration in the finger that hasn't healed and first prescribes treatment for it. So we concede that you could say that was when the injury started to become manifest, and the claim was actually filed within 4 months of that date.
So if your client, let's say, broke their arm, all right, and that later turned into this bone infection, does that change anything? It broke the arm at the accident, does not file any workers' compensation claim. The condition devolves, as Judge Catani said. Is there any requirement that your client have filed something on the broken bone, or can they wait until the unanticipated infection a year later?
No, he would have had to file the claim within a year from the time the broken bone. And if he didn't, if he had actually had a broken bone in this case, then I would not be here. There would be no prospect of arguing that he can later file the claim for the finger injury.
What if there's just a hairline fracture and you don't really need to set anything, but then it turns into an infection?
Once again, Judge, a hairline fracture is actually a fairly serious injury, and it's not slight or trivial. It requires further medical attention. Going back to the Pacific Fruit Express case, the reason they didn't make a decision about whether treatment or diagnostic related expenses was enough to trigger the statute of limitations, they said, well, this guy with the hearing loss, he was clearly going to need further medical treatment. He had an injury that was permanent. Permanence is part of the equation.
That raises a question. Let me change the facts of this case. There's a fractured rib on the right side after the accident. No question. Diagnosed the next day. No claim filed. Yet the hand wound, which was covered by a Band-Aid, devolves, bless you, into an infection and an amputation. Does there have to be an initial claim on that? And does there have to be a reopen, I guess is what we would call it here, in order to move forward? On the ribs within the year, and then?
Well, no, I think there has to be a claim filed for the rib injury as being more than slight or trivial, and
but
then
nothing is filed. But then the hand wound turns into this.
Then I think you have it would be a much more difficult problem for the injured worker not having filed a claim from.
So it's a single injury that has to be, in your mind, serious enough to warrant. This isn't an injury-specific inquiry where we look at the hand and the flesh wound and we assess that in a vacuum. You're saying you look at the body as it exits the truck. If any injury is serious enough, the limitations clock begins. Is that your argument?
I think that's true. If there was a more than slight or trivial injury, then the claimant should have filed the claim within a year from that, and the later development of the finger problem would be a compensable consequence no matter how long in the future it first arose. So, yes, that would be a different situation.
There's no case support for the proposition that your client would just be precluded from any compensation for the other injuries, but could seek compensation, even assuming a broken bone. Is there any support for the notion that he is precluded from ever getting any compensation for that injury, but is nevertheless not precluded from pursuing something that develops much later?
Judge, that's an excellent question. I would be happy to argue for the claimant on that situation, but that is not what happened here, because we're saying that it's pretty clear that the original injury, despite all the x-rays, was pain. I mean, it was just some pain. It was not a real injury. It was clearly slight or trivial.
Well, you're saying it's pretty clear, right? That's your adjective. But it's a question of fact, right? And
yes. Mm-hmm.
Is there some sort of legal doctrine that says pain isn't? I mean, your argument is that, as I understand it now, the injuries as your client exited the vehicle weren't claim-worthy. You didn't need to file any claim at that point, and the only time that things became serious enough was the next year, April, and then successive in August. And so the question then, I guess, is whether or not we have to look at that body as it exits the vehicle, and is that serious enough to file a claim? And if it is, you're saying the limitation clock begins.
I think so. We've conceded that. We've conceded that even though it was all diagnostics, he could have filed a claim. I don't think that precludes the court from saying, still, disagreeing with the judge. I mean, what I'm saying is that there's really not reasonable evidence in the record to support the ALJ's claim that this injury was more than slight or trivial just because of what she called, quote, extensive imaging, close quote. And like I say, there is now some support in Pacific Fruit Express for that type of argument.
And that wouldn't be a factual determination that we would defer to if the court, could we look at the record and say the court disagreed and thought that overall there was enough that something should have been filed? Is that something we would need to defer to, or you're saying the evidence doesn't support that at all?
I'm saying you can certainly look to see if reasonable evidence in the record supports that determination by the judge. And I don't think there is. I think all of the evidence, like I say, is that there was no medical treatment. Even after the x-rays were reviewed, there was no medical treatment. The doctor said go buy an over-the-counter wrist brace, and he did, and he recovered.
What about the statement in the medical records where your client apparently says, I'm hurting all over? Is that, you said all the evidence, your statement was, points in your direction, that there was nothing to see here, nothing serious enough to implicate a claim. What about that fact?
Well, I don't think that's important. Certainly he was sore, but he was not going to see a doctor other than his diabetic appointment, and no actual injuries were ever diagnosed except pain. Pain alone would not sustain the diagnosis of an injury, especially there's no disability attendant to it either. He doesn't miss any time from work because of the original accident and the pain. So that's why I'm saying that, no, I think you could actually look at the record and say there's not reasonable evidence to support the judge's determination that there was an injury that was more than slight or trivial. And especially in a situation like this where a very hard-working guy loses his index finger later and files a claim a month after the statute of limitations passes in terms of the original injury, is that the law, being construed liberally, should accommodate that type of claim. All we're asking for is that the claim be considered timely filed. We still have to litigate causation. And, Your Honors, if you don't mind, I'd like to save my couple remaining minutes for rebuttal.
Thank you, counsel.
Thank you, Your Honors, and good morning. My name is Sean Moore, and I represent the respondents in this case. I believe that the facts and the law presented by this case are fairly straightforward, so I will try to keep my remarks brief unless the court has further questions for me. All that is required for affirmation in this case is some evidentiary support for the Industrial Commission's rulings, viewing the evidence in the light most favorable to upholding those rulings. And viewing the evidence within that light, I believe that it is fairly clear that the court should affirm the ALJ's decision in this case.
Could I ask you the same question I asked earlier? Assume Mr. Moe had filed a claim immediately after. In your view, would there be any restriction on coming back later and saying my finger, which I didn't originally think was a serious injury, has now become infected? As a result, it was a cut that was suffered from that. Would there be any restrictions on reopening the claim?
Right. The restriction, as far as I'm aware, Your Honor, is that there's something new and unexpected that develops from the injuries sustained in the industrial accident.
Well, and do you disagree that this is something that's new and newly developed? Correct,
Your Honor. I disagree with that completely. The flesh wound, as Your Honor called it earlier, was present at the time. Mr. Moe knew that the flesh wound was there. Mr. Moe knew that the flesh wound was related to the injury.
Let's say that was the only injury, and there's just a cut on the finger. Would you expect him to have filed a claim based on solely a cut that at that point is not infected and he just has a Band-Aid over it? Would that be a realistic date to expect a claim to be filed?
Okay, so if we go with the hypothetical here, which is a hypothetical, that it's just the finger cut, I believe that, maybe for a few days, maybe a week or two, you would think, oh, well, this finger cut, it's just a cut. But, I mean, if a cut doesn't heal over time, that shows permanence. That shows seriousness, particularly in a diabetic.
What if it heals and there's an underlying infection that it seems to have scabbed over, but you're not aware that there's an underlying infection?
I mean, if the cut heals and somehow there's an infection in there, Frank, I'm not a science individual. I don't know whether that's even possible. But if that was somehow the case, where a cut could completely heal and there was an infection there, and you were not aware of it until until later problems manifested, I could understand. I mean, the rule for discovery here is basically the discovery rule. One should you reasonably
But you're agreeing that it's not necessarily the date of the accident on a cut to the finger. That it could be, you're suggesting it could be a week later, a few days later, a couple of weeks later, but okay.
I think that taken, if it's just the finger cut in a vacuum, I believe that could certainly be the case, that it's not serious enough to rise to the level of requiring.
If it's 2 weeks, if we're just moving that out, the symptoms manifest themselves a month later, where it starts looking like there's going to be an infection. And if it's a month later, he seems to be within the limitations period.
I mean, this is taking a lot of hypotheticals, but if
It's not a hypothetical.
I think it is, Your Honor. I mean,
33 days.
33 days, yes.
So we're asking you,
I
what
think
is the evidence that within 33 days on this record that Moe knew he would have a bone infection that developed a year later? That's not a hypothetical.
Well, I think that there are a couple distinctions that need to be made here, Your Honor. First is that you don't necessarily need to know that there's going to be a bone infection specifically in order for the claim to become compensable. You just need to know the general nature of the injury.
Know that something's serious.
You need to know that it's something serious. And particularly in a diabetic, a wound that is not healing is a very serious situation. I mean, it's within the medical records. It's in Mr. Moe's.
Is there any kind of expert testimony or something? You're acknowledging you don't know. It's probably not the day of the accident. It could be a little bit later. Don't we need somebody to tell us that it's any reasonable person, even a reasonable person with diabetes, would know that this type of injury is serious within 33 days of that accident? I'm puzzled as to what the date is that we should pick. If you're acknowledging that it's not necessarily the date of the accident, do we necessarily have to find a date somewhere between there and the 33 days to make this untimely?
I mean, so I don't think that you need anyone to tell you, particularly when a cut becomes serious enough. One of the key factors or one of the supporting factors, I guess, in determining whether or not a claim is compensable is permanence. Now, if it's just like seriously a paper cuts don't take a month to heal. Paper cuts don't take 3 weeks to heal. Paper cuts take like a few days to heal. If a paper cut or something that resembles that is taking much longer than that to heal, then that shows the kind of permanence. And I mean, this is an open wound. An open
Is
wound
that the rule
exists.
you want us to just have much longer then?
I mean, the rule is, I mean, I don't think there's any bright line rule here. The rule is, when is it considered serious enough to receive treatment under the statute ARS 23-1062?
Counsel,
And
are you familiar with this Sherman case?
I'm not, Your Honor.
So let's go ahead and throw some facts out.
Sure.
Let's say you have a claimant that files a workers' compensation claim based in 1985 based on a rash.
Okay.
Sorry, 1975. In 1985, that rash leads to osteomyelitis, a bone infection. 10 years passed between the rash and the bone infection. Is that time barred on a workers' compensation claim, the bone infection?
Well, I mean, it's hard for me to say because I don't have the medical knowledge necessary to know whether a rash would tend to lead to osteomyelitis. In this particular case, this is an open wound, right? It's common knowledge that if you leave an open wound there without receiving treatment, without it healing over, it's going to get infected over time. This is not a new or unexpected consequence of the wound.
At what point? You're saying necessarily within 33 days, you have to know that this is not healing and it's going to lead to something serious?
I believe that based upon the record before us, you should know that a wound that is not showing any healing whatsoever is in fact...
Which date? Because we're agreeing that it's not the date of the accident. And so I'm hard-pressed to understand what the decision is below in terms of what was the date that he should reasonably have known.
Well, just as an initial remark, I would like to say that the ALJ found that he should have known that it would have manifested problems less than a month out from that. And that's why she found that his testimony that he did not know that this would be a problem was not credible. So just as a factual finding, that's already in the record, Your Honor. But to go further than that, to answer your question more directly, I mean, it's tough for me to pick like a specific date, but I would think that if you have a wound, an open wound, that's one that's not even that big, that has shown no signs of healing, is in fact getting worse over time, which is what he testified to, I would say that shows the kind of permanence and the kind of seriousness within a couple weeks that would lead someone to seek medical treatment and the kind of medical treatment that's compensable under the statute.
How does that mesh with the availability? Let's say it had a broken bone initially and he had filed a claim. Why do we allow him to reopen for this wound if you're suggesting that if he had filed something originally based on a broken bone that's arguably unrelated to the finger, and under that set of circumstances he would be allowed to reopen to bring a claim based on the cut and the infection?
Well, I mean, it depends upon the facts, Your Honor. For him,
under those facts, he had a broken bone and he filed a claim. If he had filed, say, 2 months later, he'd ask to reopen it and pursue a claim based on the cut on the finger. You're saying that would be okay?
I don't think when he's attempting to try and reopen the claim for the cut on the finger, if that is outside the statute of limitations originally, and the cut on the finger had existed from the beginning, I would say that is not able to be reopened because it is not a new and unexpected consequence of the injuries that he knew he had stemmed from the industrial accident.
So you're saying there is a limitation on reopening?
Right. Well, the limitation on reopening is that it's something that could not have reasonably been brought earlier, something new and unexpected, something that the claimant can't have known that they needed to receive medical treatment for at the time that the claim was open and during the relevant limitations period.
What's the injury here?
The injury here?
Yeah.
The injury here, I mean, if we're talking about the nature of the injury as far as claim accrual under workers' the injury here is an unhealing open wound. And then that unhealing open wound...
Not a bone infection or an amputated limb?
I mean, those were the consequences of the injury. But the injury here was an open wound that refused to heal in a diabetic.
Okay, so let's say that's right. You have a couple weeks go by, it hasn't started closing up. he goes to the doctor. The doctor takes an MRI. Is it going to show a bone infection?
That unfortunately. I don't think. Well, a couple answers.
I think what you're saying is basically anytime you have a wound that hasn't closed within, 2 weeks?
I mean, that's
you have
my
to file
lay
a claim,
estimation.
And if it later devolves into an amputated limb, you just got to err on the side of caution.
Well, I think that, I have a couple responses to that, Your Honor. The first one is that when we consider when a claim accrues in workers' compensation, you look at the nature of the injury. The nature of the injury, by the stuff we provided in our brief, is not the specific injury that they're claiming, but just a general nature, like a hurt shoulder or a hurt knee, something along those lines. This is a flesh wound that refused to heal, and that's the nature of the injury. He was aware of the nature of that injury from the beginning. But let's take his argument to its logical conclusion here. Any injury that has where it would progressively get worse over time, the statute of limitations is completely ineffective for that, right? So you're saying, how was I supposed to know that this would go to the next logical conclusion?
Why can't we have a rule that says when it's reasonably clear that when a reasonable person would realize that the condition is serious? Do we really want people filing claims based on a cut on their finger? That seems like we don't. Why would we want to clog up the system with, I have a cut on my finger, I've got to file it, so I'm within the statute of limitations? Why wouldn't the better rule be to wait until a reasonable person would know that there's something serious? The only injury we're talking, so he has zero other injuries,
right.
He hasn't been to the doctor, he has a cut that he's put a Band-Aid over.
Right.
So why wouldn't the better rule be when it becomes something that a reasonable person would believe is a serious injury that would be compensable?
I think that the rule that you've said, the reasonable person rule, is the rule and should be the rule. And applying that rule here, he should have noticed and known that this unhealing injury was a problem less than a month out from the time that the injury occurred. I think that the reasonable person rule is the correct rule here. And if we look at the findings made in this case, that's exactly what the ALJ determined. The ALJ said, I don't believe that it's credible when you say I didn't know that this was a problem.
Are you saying, going back to my question, I asked you if the doctor had taken the MRI within 33 days. You're saying that's irrelevant, whether it would have shown a bone infection or not?
I'm not saying that it's irrelevant. I'm just...
Is it relevant?
What I'm saying is, if it would have shown a bone infection, then certainly we know that I don't know whether or not it would show a bone infection. What I'm saying is, as long as he knows the nature of his claim, which was here an open and unhealing wound from which complications later developed, then that becomes a compensable claim once he knows that it's permanent and serious.
It's not compensable the first week before those complications develop. Surely we're not suggesting that he should file it and anticipate that complications are going to develop.
I mean, if the thing is, in a situation like this, where you have an open wound that refuses to heal, I absolutely believe that you should file it in anticipation of complications, because open wounds develop complications. That's just the nature of what open wounds are. That's why you keep antibiotics on. That's why you put Neosporin on a cut. That's why you keep Band-Aids on them. Everyone knows this. It's the natural and logical progression of the problem.
So doesn't Arizona law say that an employee is not expected to know the nature of the disability or its relationship before they are reasonably ascertainable by the medical profession?
Mm-hmm. Okay. I mean, I believe that is the law, but the key is they don't have to make the specific like his finger wound doesn't have to become necrotic before it becomes compensable. It just has to become a serious problem that needs to be addressed with medical attention, the medical attention described under the statute. And when you have an unhealing wound for weeks and weeks,
okay, let's say he goes back to the doctor after 3 weeks.
Okay.
Hasn't healed, and the doctor says, okay, well, looking at this doctrine I just told you, let's take an MRI, and there's no bone infection. It's not reasonably ascertainable at that point by the medical profession.
Again, I think that the focus here is wrong. The focus is not on the final thing that resulted in the amputation of his finger. The injury here is the opened and unhealing wound. So even if the MRI could not detect the bone infection at that time, even if osteomyelitis has not actually appeared on the scene, so to speak, we still know that the cut is a problem. This is an unhealing opened wound in a diabetic.
And you go to a doctor, and the doctor says, keep a Band-Aid on it.
Well,
that's serious enough?
Well, that's not what happened here. That's not what happened here, Your Honor. The fact of the matter is the doctor was never told about the open wound, and presumably, since open wounds in diabetics are known and recurring problems.
And then that's the other thing. So isn't this a test of a reasonable person, or are we saying, though, you take the subjective circumstance of the employee who might have some let's say auto aids, and so they can, and so you're saying that the workers' compensation test is subjective in that circumstance, that you have to look at the mind of that person. It's not whether a reasonable person, or is it whether a reasonable person would know that a diabetic would?
Well, it's the reasonable person test, as far as I'm aware, Your Honor, is always a reasonable person in the shoes of the party concerned. So this would be a reasonable person in Mr. Mo's shoes, a reasonable diabetic who has an unhealing cut on his finger. When should that person know that they have a considerable problem? And I would say that if you have an open festering wound that's not healing, that is only getting worse over the course of a month, you know that you have a significant problem that you should see a doctor about, even if the final terminus of that disease has not, or that problem has not yet manifested itself. That's like someone showing up to a doctor saying, you know what, I found out I have stage 1 lung cancer, and then doesn't file a claim. They know that it's related. And then when they show up, a few years down the road, they're like, oh, I have stage 4 lung cancer. How was I supposed to know that stage 1 lung cancer would have progressed into stage 4 lung cancer?
That's similar to here. Stage 1.
I mean, obviously it's taken a bit to the extreme, but
versus a cut on the hand and an amputation. That's your.
I mean, obviously, I took that analogy a bit to the extreme, but the point that I'm trying to make is we don't consider the final terminus of a disease for when the claim becomes compensable. Otherwise, a statute of limitations in this area would be effectively meaningless for these types of claims, because it would always be, oh, I didn't know the next thing was going to happen. Oh, I didn't know the next thing was going to happen. Oh, I didn't know that the next complication would develop. It's the root cause of these problems that is the industrial injury. The industrial injury here is the open wound to his finger that refused to heal. Now, when complications develop down the road from that, obviously, those are the problems that eventually result in the amputation of the finger, but that's not what the law looks to when determining when the claim accrues. When the claim accrues is when the injury becomes serious enough and the party knows the nature of it, and the party knows that it's related to his work and to an industrial injury. So in this particular case, the nature of the injury is an open wound that refused to heal. The complications that developed later on down the road aren't what we're going off of to determine the statute of limitations, or as I said earlier, the statute of limitations is effectively meaningless for these types of claims.
And
now,
if this court disagreed with you in Sherman, good law existing today, a rash 10 years later develops into a bone infection, that's wrong.
I don't think that's necessarily wrong, and it's hard for me to say because I don't know the medical background behind this rash. Like, to me, a rash is not something that would naturally, and that a reasonable person should know, would develop into a bone disease. But to me, an open wound that gets worse over time, that refuses to heal, the reasonable person should know that that's eventually going to develop an infection and develop complications down the road.
And every reasonable person knows that it's within 30 days that you've got to resolve a cut on your finger, that you necessarily know that it's a serious injury by 30 days.
Well, I don't think you have to resolve it within 30 days. I think that within 30 days, if a wound is getting worse instead of better, particularly if you're a diabetic, then you should know that this shows a type of seriousness and permanence that would.
It's not healing. It's just it's not. You don't really see any signs of an infection. It's not healing. But a reasonable person necessarily needs to understand within 30 days or 22 days, whatever the number is to get us within the statute of limitation, that has become serious enough to file a claim.
Well, a couple things to take in mind. One, that was the finding of the ALJ, and I believe that the evidence supports that. And based upon the standards of review, I believe it should be affirmed for that reason. But two,
the evidence is just that there is a cut, and no medical testimony that this is an obvious consequence from a cut that just has a Band-Aid on it.
Well, I certainly believe that if, particularly in a diabetic, because it's always the reasonable person in the shoes of the party involved. So in the shoes of the reasonable diabetic, if you have an open wound that over the course of a month does not heal, but only in fact gets worse, I believe that shows the kind of permanence and seriousness and the potential to develop later complications that should let them know that they need to go seek the exact kind of care that is covered in ARS 23-1062.
So are we just a couple of days outside the limitations period?
I mean, again, it's hard for me to place like a specific date on it, but I think that, we know through our lives that cuts get better over short periods of time, and if they in fact get worse over a longer period of time, that should indicate the type of seriousness, permanence, and potential for problems that results in claim accrual. Thank you,
counsel.
Your Honors, what I want to point out very quickly is that it is the reasonable person rule, but this man had only been a diabetic for about a year and a half and had no prior diabetic complications, so that's why it took him longer. Second of all, it was not an open flesh wound for many months after the injury occurred. It was a little laceration that he put a Band-Aid around, and that took care of it. That's probably all the doctor would have done. So really, there's absolutely no medical evidence that this finger problem was an open flesh wound in any time between July of 2016 and early April of 2000.
Were the X-rays? Was there an X-ray on the hand?
There was an X-ray on the wrist that showed some swelling and nothing else, and the Band-Aid was already on the claimant's finger at that time. The other thing, Judge, that is wrong is the judge never found, you can look at this over and over, the judge never said that he should have known within a month about the finger injury. What the judge said, and the reason she found him not credible, was only because she thought he was saying that he didn't realize the truck accident and the soreness should have started or should have led him to file a compensable claim. She didn't say, and she would have had no reason or evidence to support her if she had said that the finger injury was manifest before April of 2017. She never, ever made a finding that the finger injury was manifest at any particular time. All she said was that he knew he had a accident or injury, even though because of the extensive diagnostics, and he should have filed the claim within a year from the time of the accident. She made absolutely no finding that the finger injury became manifest at any particular time. Reasonable diabetic, like I say, there's no reason to suspect that he should have figured out at that point that he could have filed the claim. So,
but counsel, I think you're saying that if the ALJ found the injuries from the accident were not slight or trivial, not looking at the finger, your client has no claim.
Well, that's how she resolved the case, correct? And what I'm saying is that there's not reasonable evidence in the record that supports her saying that he or that the finger injury was manifest and or that the injuries were more than slight or trivial. There's no reasonable evidence in the record to support that claim that the ALJ made. So she didn't find him credible or not credible about the finger. She never said anything about that. All she said was, and it's in the decision upon review where she actually admits, and she says, quote, this is finding number 2 of the decision upon review. While he may not have known his finger was going to become infected and require amputation, he certainly knew he was injured enough to require treatment. Clearly, she was referring to the treatment that Dr. Makija, or the x-rays that Dr. Makija gave him the day after the accident occurred. Clearly, that's what she was talking about.
Thank you, counsel.
Thank you, Your Honors.
Thank you for your argument today, and we'll take it under advisement and have a decision in due course. We're adjourned.